Hey, I'm Natalie, and welcome to the Dyslexia and Adults podcast. I believe that dyslexia is holding you back in your career and impacting your daily life, and ultimately slowly chipping away at your confidence. And I just simply don't think that is good enough. I don't care when you were diagnosed, if your boss is a total dick, or if, like me, you roll your eyes heavily when dyslexia is called a superpower. I know I can change how you feel about your brain. Okay, thank you so much for coming. Let's get started. Welcome back to the Dyslexia and Adults podcast. I have a very exciting guest with me today. I was at the Dyslexia London conference a couple of weeks ago, and Chris got absolutely bombarded by questions from everyone at the conference, and it made me realize that this is a topic that all of you will be so interested in. So, this is about the UK Equality Act, which covers neurodiversity and is a lot of the protections that we get in the workplace. So it's a really useful understanding of what you can ask for, where you can go if things are going wrong, and generally just to understand the protections that we have in the UK if you're abroad and trying to think, how can my country do things better? So I'm going to be introducing Chris and getting him to do a little bit of an overview on his experience and his expertise, and then we will dive straight in. So Chris, give us a little bit of an overview about you.
Thank you very much. And it's nice to be referred to as interesting. Not many people describe lawyers as interesting. So,
I found your
um,
presentation fascinating.
yeah, thank you very much. Yeah, I'm a lawyer. So I've been a lawyer now for coming on 12 years, I think. And I've started, or over the last 10 years or so, done quite a bit of work in the pro bono sector. And interestingly, we're talking in the week that it's National Pro Bono Week in the UK, so quite an important time and kind of in the context of this, very relevant. Where we support a lot of people who kind of have legal issues but can't afford or are sort of unable to kind of access legal support, and kind of through that got involved with Dyslexia London and sort of started working with them to develop some, well, initially some training and then also some FAQs about sort of supporting the dyslexic community and the neurodiverse community in understanding the law and the kind of protections and we sort of like to describe it in the sort of legal world, the sort of the weapons that you have at your disposal to be able to kind of fight your corner. So just sort of basically legal education in that sense, just because I think it's a lot of the case people just don't know what their legal rights are, and that's the kind of very starting point, and then you can kind of build on that from the bottom up. So that's kind of what I've been sort of focusing on, and obviously kind of at the conference where we met, that was part of the reason of that, to kind of showcase some of the stuff that people might be able to use in the workplace in relation to the Equality Act and the some of the fantastic protections that gives to people.
Could you start by giving us a quick overview on the UK Equality Act and how it applies to dyslexic individuals in the workplace?
Absolutely. So the Equality Act was a piece of legislation which basically sort of brought together a lot of anti-discrimination legislation that existed in the UK, and fundamentally it provides protections against what are called protected characteristics, and these are sort of a range of things from sort of age to sex through to disability, and under the disability sort of bracket, a lot of neurodiversities are sort of included, and in dyslexia in particular. And that means that you're entitled to what are called reasonable adjustments, and we can kind of talk a bit more about that later on. But also just sort of protects you again about being discriminated against because of your neurodiversity or your, dyslexia or any other protected characteristic.
And obviously, this concept of reasonable adjustments is kind of purposefully vague, but it is quite confusing for individuals. So, what exactly qualifies as a reasonable adjustment?
Yeah, that's a great question. I mean, um, I suppose to sort of break it down into its two parts. So it is an adjustment. So in the sense that the way that the workplace would be, I suppose, ordinarily set out or kind of set out by the business. So it's something which is changed in the way that operates. to adapt or sort of level the playing field effectively for people who, because of their condition or other special characteristics, actually would benefit from it being slightly different. So that's kind of one level of it. And the reasonableness element of it is, as long as it is not sort of completely disproportionate, I will cost an excessive amount of money, or be really difficult to put in place, then that will be reasonable. And therefore, so as a dyslexic person, identifying something or a sort of means of operating which will make your life easier, as long as it is reasonable, then the employer should provide you with that.
And so what you're saying is that it was kind of intentionally left vague, although it's frustrating for us because we're just thinking, well, could you just tell me what it is? It's
Yes.
left vague because people need to be able to allow for different things in different circumstances. So we should kind of see it as a positive that it's vague.
Yes, absolutely. I mean, as a result of kind of case law and experience, there are lots of things which kind of have been accepted that are reasonable. And the Dyslexia UK website provides a great range of things on that. And ACAS, which is the sort of employment law ombudsman in the UK, does too. Um, but if there is something specifically for you, because I suppose everybody, the neurodiversity is unique to them, and therefore the things that they might find helpful, if you can make a case that that is a reasonable adjustment, then that should be at least considered by your employer. So yeah, absolutely, the vagueness is useful.
Is there anything specific in the case law that you think people would find interesting or you would want to highlight?
I think fundamentally it is about being empowered to ask for reasonable adjustments, and the case law is um, comes down quite hard on employers who sort of refuse it offhand. And I know one of the things that, not from the case law necessarily, but from experiences of speaking to people, they're afraid to kind of even suggest it to their employers because they're afraid of the implications of doing so. So I think just people feeling empowered that actually the law is on their side in this sense, and the case law kind of holds it up. So as long as you are able to present what you think is a reasonable adjustment, or actually the employer as well should be suggesting things too, that you should feel empowered to ask for that.
Hmm, that's really interesting. I like the kind of the feeling that the law is on your side because I think it doesn't feel like it is in our kind of day-to-day experience, but actually, if you know in reality it is, that can be really helpful. And one of the other things that I hear a lot that would be interesting from a legal perspective is when someone's going to their employer and they're saying, I'm asking for this adjustment, what do they need to provide or be prepared to kind of show to be able to get that reasonable adjustment? Do they need that formal diagnosis?
Well, they don't need a formal diagnosis necessarily. That can be helpful because that can highlight particular things that might be of help. There are sort of organisations and schemes like Access to Work in the UK, which will sort of make suggestions around what could be useful, reasonable adjustments. And some employers will have occupational health teams which will be able to support that. But I think the important thing, again, to sort of emphasise is that the obligation is on the employer. Obviously, it's very helpful if you come to the employer and say, you know, as a result of my condition, I would find X, Y, and Z useful. But actually, it is for them to kind of help facilitate that. Um, so I think that's a really important thing to bear in mind. Although, as I say, actually, most of the time, it will be the employee that will have a better sense of what will help them, and probably has done more of the research around these things. So that can always help, but you don't necessarily need to sort of provide, oh, I need this, I need this, I need this, but it can help.
And where you were saying it's on the employer to kind of support, does that mean also getting a diagnosis or paying for someone to understand the complexity of the needs? Does that also fall under reasonable adjustments or kind of the role of the employer?
It can do. And in this, it depends on kind of how your employer will interpret that. It's not an area that's been explored explicitly, I don't think. But if that is something, and that's where kind of the occupational health side of it will come in, they will then explore with the employee kind of what they might find helpful to kind of make their working environment better suited for them, and whether that is assisted by a sort of formal diagnosis or working with a specialist who might be able to suggest things. I guess that might be facilitated through that. I think it will also, I mean, depend on the way that the employer will focus it. And as I say, with bigger organizations who have more occupational health support around them, they might take that route.
That was going to be my next question is you were saying that reasonable is kind of cost and impact the business, but with cost, is the size of the business taken into account as to what's reasonable and what's not?
It is in the so if it were to be challenged, I think the courts would take a view, and obviously, a smaller organization would find it more difficult to accommodate a reasonable adjustment that was more expensive than perhaps a large organization. But I think the thing is, particularly around some of the adjustments that can be made to support people with dyslexia, they're usually relatively small costs. It's more about the sort of working practice, the way that people communicate with others, and just sort of making people aware of the things that can help somebody who has dyslexia or a neurodiversity in being able to do their job properly. So providing a bit more time, maybe delivering something orally rather than in writing and things like that. So actually, although there may be sort of software and technology that might help, actually the first thing to look at is all those other things.
Yeah, we completely agree, and that those small things can make a huge difference. So, moving on to like navigating the legal process and the enforcement side of things, for someone who is kind of sitting there with their employer, not feeling like they're supported, and they're like, no, do you know what? I want to take this one step further. I'd love to get your feedback on, what people should kind of do and like what's the process if someone wants to go forward with a complaint?
So is in sort of most settings, I guess that if you've asked for a reasonable adjustment and your employer has refused it, the next level would be to raise a grievance within your employer's sort of grievance process, and all employers should have some sort of policy around that. That will then mean that they have to look at it in a sort of more formal setting and consider it in a bit more detail, and then they might come out with an outcome which may agree or disagree with the reasonable adjustment. If you get to the end of that process and your employer is still refusing to give you any extra support, or that give you the reasonable adjustment that you were looking for, then you can take it to the employment tribunal, and you would bring a claim to the employment tribunal. But the thing that, particularly in sort of England and Wales, is to be aware of the time limits around that. So you have 3 months from the point at which the grievance ends to lodge that claim.
Okay, yeah, that's a really useful piece of information. So just so I understand, so if I'm in a workplace, my reasonable adjustment has been denied, I'm feeling frustrated about that. I lodge a formal grievance. From that point, I have 3 months to take it to the tribunal.
So the end of the grievance process. So once you've worked through the grievance process, and then that then finalises, and you get kind of an ultimate decision about from your employer, um, that they are not going to give you the reasonable adjustment. That's the point at which um, you would then, yeah, that's the trigger point for the 3 months. It's also a useful thing to know in between then. You can, again, in England and Wales, you can apply to ACAS, which is the kind of employers ombudsman. And by applying to them, they mediate between the employer and the employee. That stops the clock. So it gives you more time to be able to process things.
Okay, nice. And I'm just thinking about back to some of my more frustrating workplace experiences
Mm.
and whether or not I would have gone ahead with this type of thing, because there's definitely situations that I had that would have met this criteria so far. Do you, what's the kind of cost implication is one of the things I'm thinking would be my first barrier. So do you need legal representation? Can you do it yourself? Is there fees associated with it?
Yeah, it's a great question, and I think that's one of the sort of barriers I think a lot of people have in terms of making this decision to kind of challenge the employer. I guess, fundamentally, you don't need legal representation, although I can see that that would be really helpful to most people to kind of like give them that support. So, and as I mentioned to you before, that this is National Pro Bono Week, and one of the things that I would really strongly encourage is if you are in this situation and you don't sort of have the financial means, do try and find a legal advisor through one of the legal advice charities or through university advice clinics, because they can sort of help you through this process for no cost. Or, if you're able to afford it, obviously get a lawyer because they can help as well. There are court fees as well that you just need to be aware of if you are going to take a claim forward into the tribunal. So it's depends on the way you approach it. But it's not, at the very least, you're going to be paying some of the court fees associated to it,
Mhm.
which can be a barrier as well, I guess.
Yeah, for sure. And so if someone is thinking about going through this process and they're thinking about this cost outlay, once you go through the legal process, what can you get as a result of it? So I put, I put my grievance in, I felt frustrated. I thought, no, this
Yeah.
is unacceptable. I'm going to take them to court. What am I hoping is my outcome?
Yeah, well, there's a sort of a range of things that the tribunal can kind of award to you. One of which might be damages. So they might actually say that the way that the employer has behaved has kind of created such harm in relation to and discriminated against you. That's the fundamental thing, actually, by refusing to give you the reasonable adjustment. That is actually a form of discrimination. So they can give you damages. So that could be an award of money. Um, which might be helpful. They will also probably order the employer to actually give you the reasonable adjustment and can make directions about that. So it depends on kind of where you are, I suppose, and whether you're still in employment with that employer. Because I suppose one of the problems as well around this is that it might have broken down in terms of the relationship with the employer, but it could mean that they are actually enforced to give you the reasonable adjustment, and that can often happen.
So it's getting the reasonable adjustment or potentially getting damages.
Or both, or
Yeah, or
both.
both. Okay, interesting. And again, I'm kind of thinking about my past experiences. And if there's anyone listening here who's thinking, do you know what? I was treated terribly in a workplace. And a lot of the time I hear that people just decide to leave because they can't handle it anymore. Is there anything that can be done retrospectively, or is there anything that can be done if you haven't asked for a reasonable adjustment, but you just feel like you've been spoken to horrendously, like dealt with horrendously, and you just want to kind of get those damages kind
Yeah,
of spoken to?
yeah, absolutely. I mean, and this is one of the things, the Equality Act, as well as, providing for people to be able to access reasonable adjustments, does talk about discrimination. And a lot of the time, as we said, um, it can be an act of discrimination to refuse reasonable adjustments. But equally, there's all those things that get said around, even asking or suggesting that you might need some of this support, which are, directly discriminatory. And and if it is getting to that stage, again, the the thing would be ideally to kind of raise a grievance within your internal employment process, and if that doesn't get anywhere, then take them to the tribunal. Equally, as well, as if you've already left, um, and if because of discrimination, um, was the reason why you left, there can be opportunities to again make a claim for damages for the discrimination that you've suffered, and that is often an avenue that people pursue, and it's slightly different in terms of the time scales around that. So it's not quite as tight.
And for when we're talking more about a grievance from discrimination perspective, do you need to have raised a grievance or is it just helpful?
It's helpful, absolutely, because that shows that you've gone through all the processes, and what you're trying to sort of paint is a picture of an employer who's being entirely unreasonable. And as another sort of side thing to all of this, I think, is if you feel like this is happening to you or has happened to you, just bring together as much information as you can, sort of diarize it if you're able to do that, just so you've got all that evidence which you can then present if it ever gets to the point where you're having to bring a claim, and it makes things much easier. You don't necessarily need it, but it just makes things easier in terms of developing that claim.
And we've kind of gone down a worst case scenario perspective, and I loved what you were saying about that feeling of the law being on your side. Going back to try when you're trying to kind of have that initial conversation with the your employer, is there anything you would kind of give advice to people kind of who are starting to have that conversation of I'm dyslexic and I'd like this support or if would find this useful, kind of to assert your rights clearly, but in a positive way and trying to kind of like still foster a relationship. Is there any advice you'd have there?
Yeah, I think the main, as I said, the purpose of the Equality Act is to kind of create a level playing field for everybody. So no matter sort of what where you're coming from, you're able to do your work to the best of your ability, with the support of the reasonable adjustment. And I kind of would frame it in that sense is that, everybody wants to come to work to do their best. I'm asking for a reasonable adjustment to be able to assist me in doing that. Actually, this is going to help you as the employer. Because you're supporting me to deliver my best, and whatever it is that, as I say, many of the reasonable adjustments will be relatively minor things and more awareness raising, really, with the employer about actually this style works best for me. And that's kind of not the normal practice of the business, but it's not a huge issue to kind of do that to support me. So I would kind of frame it in the this is good for the employer as well as it's in good for me as the employee.
Yeah, that's exactly what we say as well. I couldn't agree more. So thank you so much for all of that advice. That was invaluable. I'm going to ask you just a couple of quick fire questions to wrap up. But if anyone does have any more detailed questions they want to ask or get in more detail, we are going to have Chris also in the hive and get him to answer more detailed questions as well. So, firstly, is there any common misunderstandings that you feel like people need to know with regards to the Equalities Act?
More than anything else, it's that idea that you can use the Equalities Act. I think more people need to know that the Equality Act is there and it can support them. I think that's kind of the fundamental misunderstanding is that, not enough people know that it can protect them or give them rights.
And then what are the resources, organizations that you feel like are useful ones for people to go to kind of get this process underway if they are wanting to take things further legally?
So I think one really good resource is ACAS. I would definitely recommend. They've got some really good resources around this. Dyslexia UK as well have some fantastic suggestions about things that would be reasonable adjustments. And as I say, if you kind of feel like you're even drifting into a kind of conflict situation around this, locate your sort of nearest legal advice centre or Citizens Advice Bureau, and they will be able to kind of just sort of guide you in the right direction.
Hmm. And then if there was kind of one piece of advice that you give to people about their rights, what would it be?
I think fundamentally it would be confident that, as I say, the law is on your side. It may not feel like that all the time, and it may be a bit of a fight to kind of get what you want, but the Equalities Act is an incredibly powerful piece of legislation, which employers are definitely becoming much more aware of and scared of. So do feel empowered by that.
Okay, I love that. One last cheeky question, and we haven't prepped you on this, so don't worry if you don't
Yeah.
have an answer. But what is one piece of case law that will really help people understand the value and the power of the Equality Act?
The case that really stands out for me is the case that an employee took against Starbucks. And I think the reason for that is it just shows how, even though you've got a massive corporation as the employer, that the power of an employee to be able to use the Equality Act to bring them to give them a reasonable adjustment, just sort of highlights the power that it has.
Amazing. All right, one final last quick fire questions. I'm going to list you a set of reasonable adjustments, and I want to know whether or not you think these count as reasonable adjustments. So here we go. First, an ability to be 5 to 10 minutes late.
Absolutely, yeah. That's a reasonable adjustment, and courts have determined that as such.
To have Spotify for additional stimuli if you have ADHD.
Definitely something that you can propose. I can imagine some employers would push back on that, but I think it could be a reasonable adjustment if you could show that it would help you. Yes,
Access to AI platforms to help you process information.
this is an interesting one. I think in theory, absolutely. It's one of those things that will probably need to be tested by the courts to determine absolutely that it is, but I can definitely see that has potential too.
A way to get personal, private space to be able to aid focus if you have ADHD. So that might be working from home, getting access to an office, or being able to use meeting rooms to work.
Yes, absolutely, and and the way that the world of the work is now, that should become much more easy to do and therefore more reasonable.
Mm. And what about using headphones to kind of block focus? I know that that's one that I've definitely had like been told off for in the past.
Yes, and that is absolutely, and again, the courts have determined that that is a reasonable adjustment.
Asking for agendas before a meeting?
Again, yeah, absolutely, and relatively easy one for employers to do.
A one-on-one check-in meeting to help me prioritize and plan my week?
Absolutely, yeah.
Flexible working hours?
Yes, absolutely, and in the UK, there's going to be even more legislation to protect you on flexible working, so that's going to double your power in that sense.
Wow. Okay, powerful. That's really exciting. Thank you so much for your time, Chris. It was really informative, and I know for a lot of people going to be really valuable.
Thank you very much. Great to speak to you.
And Chris, if there is anyone who wants to find out a little bit more, is there one place that we can find more detail about you?
Yeah, so if you want to get some advice on the sort of legal aspect of kind of bringing a claim in the under the Equality Act, then do reach out to the South Westminster Legal Advice Centre based in London, and we'll be very happy to support you.
Amazing. Thank you so much for your time. Thank you for listening to this week's episode of the Dyslexia in Adults podcast. Whether or not this is your first listen or your 100th, I am so grateful that you decided to entrust me with this challenge. If you enjoyed this week's episode, I would really appreciate it if you could review and subscribe to the podcast because it really helps us to reach more people.